what we was doing is going through these videos. We was on 27, so I'm gonna go back to video 26, and what I'm gonna do is actually bring it up to where you guys see me here in a minute. What you seeing is actually what you seeing is the prosecutor Douglas Hanson um, and Roger Joe Smith. These two in cahoots with illegally prosecuted me. I think it should be illegal for the police officer to be trained by the DA, the DA himself. So y'all see me going through this situation. It's been 6 years. I had to take a break because I love helping my family out, but at the same time, I like working on my case. And right now it is a good chance to work on it without the kids yelling in the background. Everybody is down. You see that this is a whole lot of different people on here. Then I got a rest cycle. What I was planning to you is Douglas Hanson need to be held accountable for his misconduct, and the reason why that is we reaching out because maybe it's time to make a difference, make a change in how they illegally doing people down in Marion County, Multnomah County. Like I said, we got to give our new elected DA a chance to figure the program out. I mean, he's not a rookie. That's the thing. He's just taking over in a time where things are not right. Black Lives Matter movements and people fighting for injustice, and then you have a person like me that's been willing to work with them on reprogramming their first off spending budget through the biennium budget, which DAs and victim advocates get state funding from like Deborah Kafori and county commissioners. If you want to know how much money is being distributed to the local DAs, I'll recommend you guys looking up 2020-21 biennium budget. This is all the state senate bills that's been approved and all the approvals of like sheriffs going in front of county commissioners, all that goes under the biennium budget. So one thing I would say is that I never ever got a fast and speedy trial. I never got received due process, and it took a lot of different people to support Douglas Hanson in getting away with this illegal conviction. You'll see several people on here, and some of them is retired, and some of them is actually taking over positions. Some of them moved away. Some of them just plain out flat. Just I don't know even what to say. What I want to do is double back though. And what I'm going to do is get y'all to some paperwork. I like that paperwork scene. I like how that's looking. One video that you will see me playing was for. What I'm gonna do is double back though. turn this down some because my wife is
I
upset.
have notes from a case that Ms. Weiland has been appointed to. She would like to come back on this matter on the 4th day of June at 8:30 a.m. for a Rule 7. She will, Mr. Johnson will continue to waive preliminary hearing until that time. And I would like to note that we've received an offer, a plea offer from the district attorney's office, and we've received some discovery, including a probable cause statement, but we haven't yet received police reports in this matter, so she'll need to review.
Well, and the reason you haven't is because she didn't waive prelim last time. She set it for preliminary hearing, which was supposed to occur on the 27th, and we're supposed to be here today on arraignment. So what's the status of that?
Of course, they never got back with the status of it, but what we're gonna do is put on the evidence versus their own voices. When we talk about the evidence being contradicting to the court audio transcripts, I am telling you something that is real serious here. If this was done to any human being, I hope like hell that they did the things that I did. Fight back. Don't let these people slander your name and defamate your character and take you away from society and take away pursuit of happiness because you spend so much time fighting, trying to get the hate off of you. So let's go over what he said. He had a plea bargain, right? He had this plea bargain given to me. Now, this plea bargain was put up underneath my door at the wee hours of the night. I don't know if that's what their intentions was, but I wasn't asleep. I wasn't up under no covers or nothing. I was up talking to a cellmate of mine in a Marion County jail, and they said, Johnson, this is for you. And it was a sheriff by the name of Ryan Dunbar, right? He slid this plea offer underneath my cell. Now, this is the original plea offer where it says my name, Matthew M. Johnson, and then it says Attorney Kerry Weiland, 5/22/2014. We're going to go back, and I'm going to show you proof that Kerry Weiland didn't even know. She didn't even know that she was assigned to me on this date. So there was no way that I potentially had made communication with Kerry Weiland in order to waive away preliminary hearing and indictment. That's been a lie, and it's always been there for them to fix, and they never fixed it. They always said that you're lying. This don't have no merit to the case. Well, this is how the case began. When I tell you, I can prove why they didn't have an indictment on me, why they didn't have a police report. Because my wife tried to go down to the Salem Police Department and speak to Lieutenant Russ Morris, right? And he was acting as internal affairs. And what I was learning is all these people was working for the better of Douglas Hanson. This is a man that worked his way up. Period, point blank. I got to accept that. He worked his way up and he became a man that people trusted, right? So in my plea offer for count one, delivery of oxycodone within 1,000 feet, let's go over that. Douglas Hanson is claiming that I'm an 8B, 35 to 40 months. And what Douglas Hanson is asking the courts to give me is 40 months Department of Correction, 36 months post-prison supervision. Post-prison supervision is after I do the 40 months of Department of Correction time. And then you got what's called a 0936. Now, this was not explained to me what a 0936 is. And for people that don't know what a 0936 is, a 0936 is telling the courts in your plea bargain that you will not be eligible for any alternative programming, any good time, any work time, any none of that. So basically, the 0936 is basically turning the 40 months into a mandatory sentence, which is considered a major 11. And then he said a $200 fines, and then that CAA court attorney, court appointed attorney fees, and then forfeit all items seized. We're going to get into that information too, and the reason for the forfeit all items seized is because none of the information that Douglas Hanson actually charged me with was in my possession or a part of me, and that's why we go here to and I like to go here because that's where it's at, and we'll bring. Let's just switch this real quick because I want the paperwork. I want to be able to show you guys the paperwork, but I also want control the video. First thing I'm gonna talk about is the forfeit all items seized and why this is just illegal for the delivery charge. We gotta look for the evidence sheet. So I will go ahead and put the evidence sheet up. And we'll go over these sheets one sheet at a time. So what we're looking for is evidence to support a delivery charge. That is what we're looking for. So what we're gonna do is just put the evidence up there on record. You see where it says 14-1818-9. If people pay close attention to that and they typed in that number, it does not lead back to promoting prostitution or delivery of oxycodone. That 14-1818-9, which is 14-0-1818-9, leads back to a prostitution citation involving my wife, right? It has nothing to do with me on 516, like, but they held me and they stuck it to me. Now, if you pay close attention where it says incident sex offense 5/16/2014, and the time basically 1 o'clock, almost 2, right? It says suspect, and then it says Jessica Johnson, and then number 2, suspect Matthew Johnson, 11/6/1984, on a birthday. Then you hear it says Miranda consent. One thing that I like to do is break. I took that class too. It's called Breaking Barriers, and that's what we're doing here is breaking barriers with Douglas Hanson. Douglas Hanson knowingly knew I didn't sign Miranda consent. He wrote this all up. I don't know if it was him or I'm saying it's him because I know.
Since the Miranda begins so early in the contact, he did not sign the Miranda.
Did you not hear what Officer Eric Hernandez said about Miranda consent right here? Where they lying at? Well, then they went under oath and told the truth, right?
And since the Miranda begins so early in the contact, he did not sign the Miranda.
Hold on.
And since the Miranda begins so early in the contact, he did not sign the Miranda.
So how do you proceed on charging somebody with a crime if you don't read them properly they Miranda rights? When you talk about, Miranda warning, and I'll read it out to you because everybody should know it, but you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have a right to attorney. If you can, 411 will be appointed by the courts. Do you understand these rights I have read to you? You either say yes or no. None of that happened to me. And I'm not saying it no more out loud. I'm not saying to the people that, I'm telling the truth. Let's just look at their own voice. Let's hear it from them. I did not sign Miranda
And
warning.
since the Miranda begins so early in the contact, he did not sign the Miranda.
Did not sign that thing. But anyways, a USB drive found in Jessica's purse. That has nothing to do with me. But since you calling her a suspect, y'all trying to pin all the evidence on me by making my wife a suspect in order to use the evidence. But I'm gonna break Douglas Hanson's back on this one because we're gonna dive into my wife case a little bit later in this segment here. But right now we going over the paperwork. And it says right here, paperwork from hotel front desk. A black LG smartphone found by Sergeant Barnett, who never on the bed, who never even came to court to testify about nothing that he supposedly found this black phone, right? And then it got a blue HP laptop serial number found on the table by Bitterman. This is another officer, Barnett, Bitterman. They never came to court. And it says password moneymaker, right? These people never came to any of the pretrial motion hearings. The only two that came to the pretrial motion hearings and went on trial was Officer Eric Hernandez and Roger Joe Smith, right? A blue HP laptop, right, found by Bitterman on the table, plus wall charger, password moneymaker, right? White pink case Samsung cell phone, right? $90 US currency found in Matthew's wallet by Smith. 1,200 US currency found in Matthew's shorts by Smith. Now, Smith is an officer that's doing the texting back and forth to my wife's phone. That has nothing to do with me. I don't ask my wife who she texting in her phone. How can you charge me with that? I don't babysit my wife's phone like that. Look at the evidence that they suppose. This is Douglas Hanson's evidence to go forward with prosecuting me for a delivery. And he knew he had no evidence. That's why he said forfeit all items seized. And what he talking about is the laptops, right? Let me explain to you why he's saying forfeit all items seized, because these laptops don't have nothing to do with me. These laptops is not mine. They don't belong to me. They was my wife's laptops. That one was a school laptop and one was for whatever she was doing. And she told Douglas Hanson that, but Douglas Hanson didn't care. He wanted to stick it to me. So what we doing is chopping down the evidence. And I got my Cornell notes, so I know exactly where everything at. So what we want to do is look for the black one right here. Is it this one? The black HP laptop serial number. Let's just look for the last 3 on the code, which you will see it right here. BRZ. Bitterman claimed that he found this laptop on the table. That's the evidence. That's the evidence that Douglas Hanson had. Bitterman is claiming that why you never subpoena Bitterman to pretrial motion hearings? Why? How was it that Roger Smith and Eric Hernandez can testify to something that Bitterman may or may have not found? It's just like who it put this together for me, right? And I said, Black HP laptop. This laptop is not my laptop. The police lied. 2. Officer Roger Smith chose to corrupt the serial number. He changed it, the serial number, to my wife's laptop, changing the last letter from Z to R. Proof this is showing that I'm a part of a hate crime. In a different area, this changed. That's why I wrote this, because I wouldn't have wrote something that. So the serial number is. You see the serial number ain't even correct on their paperwork. The serial number is right here. This is an item that's from Aaron's preferred customer ownership, and this is supposed to be a part of my defense to Gail Ryder, saying, hey man, I got all the evidence you need. That's not my laptop. I didn't have no control over that. The passwords, none of that. I didn't do none of that. This is not, and I try to produce the fact that it said Jessica Johnson. So that's the reason maybe it was in her possession. So look at the serial numbers. It's supposed to be S2, but he put C Z Z C E. He put that right there because nobody can find this. They knew that I knew I had the evidence, so they try to change the serial numbers up on me, right? So let's get to the next copy, which I would show you that this also, the blue HP laptop was never mine either. They knew this. They knew this. So Gail Ryder told me that I need to go get evidence to support me telling the truth. And I said, okay, I will do that, right? So let's take a look at the blue HP laptop, and he questioning the serial number, right? Found this is the thing. They knew they had a serial number, but it led back to Jessica Johnson again. So basically what they said is they don't know. So what computer was you looking at? If you gonna follow the rules and the serial numbers was on the computers, and it's this thing, they wouldn't have wrote them down if they didn't. They tried to change one serial number, and then they said, let's just not put a serial number. And then another officer found it. Bitterman found it. This officer never took part in any criminal proceedings throughout my case. Again, preferred customer ownership. My wife, Jessica Johnson. It was my wife's school laptop. You will see that's where I was talking about on the other paperwork. If you look at the search warrants, which I'll get into a different segment about illegal search warrants, you will see me bringing back up this information, explaining the serial numbers, and that's cold-hearted, right? So the $90 USC currency money, right? Let's just blow this thing out the way right here, so I can prove, like I said, hey, that's my civil money. I just had a check. I just had a check cut out to me. That's my civil money, right? Douglas Hanson didn't care. He didn't care about that. He didn't care about the fact that I had that much in a check from Johnson versus Arizona automobile insurance in full. This was a check that was cut out to me by Willie Merkel. And what happens is I try to reach back out to Willie Merkel for help, but Douglas Hanson had already called him on a humbug. So that ties that up. That $1,290 that they seized from me came from a civil lawsuit, and I proved it to them, and they still made a choice not to help me, right? So what we're gonna do is go back into the second part of this. This is the last. I got missing information, and this is why he's saying forfeit all items seized, because his information that the police gained as far as evidence got washed out. It was done when he made my wife early EDP offer, or early dispositional programming, right? That she never took part in. It was just to cover up, to hide the evidence, to charge it illegally to me, and they know I know that, and they trying to figure out how to stop me from telling the truth. But look, deluxe brand condoms found in Jessica's purse by Burnett. Where is this Burnett dude at? Where is he at? Where is he at in any of my court? Zipped and unwrapped Samsung Galaxy 3 white found in Matthew's hand by Bitterman. If Bitterman found the phone, how did Officer Roger Smith and Eric Hernandez go through it? If it was found by another officer.
I believe there was also a cell phone that I didn't find it personally. From what I was told, it was found in his hand. I believe at the time he was taken into custody. But
Officer Hernandez would have that information.
yes, sir.
You hear that?
East, room number 419, which is within Marion County.
So let's look at this. Roger Smith said, I believe there was a phone. You see right here where it says a Samsung Galaxy phone 3. Douglas Hanson kept that phone with all my baby pictures, with all my memories, with all that. And he looked through that phone, and he went and this is another way he was able to manipulate us. This is another way he was able to communicate through emails and all that, because he had our phones, and he was orchestrating all that. He was portraying himself to be me and my wife by sending messages from phones that the Salem Police Department seized from us. Those phones should have been turned off when they seized them that day, and we try to report that to Sprint, that the phones were seized by the Salem Police Department and considered being under investigation. So they kept the phones on, but at the same time, they charged me for that, right? So you hear Roger Smith, Right here, number 22.
I believe there was also a cell phone that I didn't find it personally. From what I was told, it was found in his hand. I believe at the time he was taken into custody.
He said the phone was found in my hand. Now, this is the thing. He said, I believe that there was a phone found. Listen to this. I believe that there was a.
I believe there was also a cell phone that I didn't find it personally. From what I was told, it was found.
From what he was told, he believed there was a phone. He didn't find it, but what he was told by another officer is that the phone was found somewhere in my hand. Right? I'm gonna just let y'all listen to both Roger Smith and Eric Hernandez take account of this. If I can get the video.
I believe there was also a cell phone that I didn't find it personally. From what I was told, it was found in his hand. I believe at the time he was taken into custody. But
Officer Hernandez would have that.
yes, sir.
But on the police report, it's clearly stating that Bitterman found the phone and that I supposedly gave Bitterman 0550. But they claim is I gave that code to Officer Hernandez. Their story is just falling apart, crumbling. Because look what Hernandez say.
Did you notice that there was a phone that the defendant had at this time?
Watch
He was in
this.
possession of the cell
Watch this.
Yeah,
This is where they stories mix
what
up
was
at.
If I remember correctly, he had it in a pocket.
Was the phone in my hand or was it in my pocket? Which officer is telling the truth
I
here?
believe there was also a cell phone that I didn't find it personally. From what I was told, it was found in his hand. I believe at the time he was
So
taken into custody.
So which officer told you that the phone was found in my hand and not my pocket? Because it most
I believe there was
definitely.
also a cell phone that I didn't find it personally.
He
From
didn't
what
find
I
it.
was told, it was found in his hand. I believe at the time
It was
he
found in my
taken
hand.
into custody.
It was found in my. This is why I'm saying they lying, because they stories is contradicting. Any real judge would have threw this case out. Like, y'all don't even know if Matthew had the phone. Was it in his hand? Was it in his pocket? Officer Bitterman is the one said he found it. So I had to talk to Officer Bitterman and to give him this password, right? How did it turn out that it's me and Hernandez talking about the phone? They lying. This is why he's saying forfeit all items seized, because he know I'm chopping them down.
Did you notice that there was a phone that the defendant had at this time?
Watch
He was in possession of the cell phone.
Watch this.
Yeah,
This is where they stories mix
what
up
was
at.
it?
If I remember correctly, he had it in a pocket.
I have the phone in a pocket. These people is crazy. So let's move on to right here where it says prescription pill bottle for oxyanamorphines found in full of pills found by Dee Bitterman Smith. They done crossed out two different officers who potentially could have found the pills. But the bottom line is that I was never in possession of my own pills. They were in my wife's purse. Why would they be in my wife's purse? Explain this to us, Mr. Johnson. Why would your prescribed medication be in your wife's purse? Because my wife is my caregiver and she was allowed to go ahead and go sign and get my prescribed medication. And it ain't my fault that she forgot to put my pills in the medicine cabinet where she could have been sidetracked. She could have just forgot anything. But they said that they charged me with a constructive delivery. But charging a person with constructive delivery means that you have to charge both parties. You can't charge just one person with the constructive part of it when fully the possession relies on the person that you did not charge, Douglas Hanson. Then I said, I just basically filled in a lot of the missing information. So what we're gonna do is come over here to the promoting prostitution 8B, 35 to 40 months, 40 months DOC time, 20 months post prison supervision to 0936, 200 fine, $1,200. Where did the $1,200 come from? Y'all know where the $1,200 came from. But they leaving out the fact that they took $1,290 from me. All the money got to be accounted for, Douglas Hanson. All of it. That's why right here, where it says $1,200 to be taken from cash seized, right here, that $1,200 right there was supposed to be applied to the victim. My wife didn't receive a dime, but they took all this money. They took $1,290. But Douglas Hanson, I got a question for you and the rest of the crew. Did y'all go out for drinks on me for illegally prosecuting me? Did I pay for that? So what we gonna do here, and I want y'all to see this, because there's very important rules of the plea bargain. Yeah, Douglas Hanson typed all here, and you see what he said: must stipulate or DA will seek maximum departure sentence. Maximum departure must stipulate or DA will seek max departure sentencing time to 140 months DOC. 140 months DOC time. He was offered, this is his plea bargain. I don't see where it say anything dealing with probation. And then right here where it says Blakely enhancement factors, he underlines specific ones that apply to me, where now what he's saying is, Gail Ryder said this the best. The DA found what's called Blakely enhancements to seek an upper departure to double the sentence from 40 to 80, and that's why you got the 80 on the side right there, because what he did is upper departure me from 40 months presumptive sentence up to 80. You see that? Vulnerable victim. Prior sanctions have not deferred. Demonstrated disregard for law. Incarceration necessary for public safety. He went on to give me DV conditions, gang conditions, DUI, conditions, drug conditions, sex offender conditions. Sex offender, register as a sex offender, DNA, HIV testing, polygraph, placenta pinto polygraph, victim counseling costs, none of that. Compulsory fines to the victim right here, where you see where it says compulsory fines, none of that, right? Comply with the terms provided, standard all cases. Court appointed attorney fees for all counts, no participating in an Oregon medical marijuana program. If on probation, pay all in all restitution. None of that I did. I didn't follow none of this. Let's listen to something right here.
You knew I was married.
Right, and the you're not a lawyer. I am.
You're not a lawyer, you're a district
I know
attorney.
my job, I know how to do it, and because you're considered a victim by the state, by me, that you don't have the marital privilege. He doesn't get to claim the marital privilege when you're an actual victim of a crime.
I'm not a victim. I'm not a victim. You made me a victim because you knew we was married. Because you wouldn't have been able to subpoena me.
Yeah, I can subpoena you lawfully, which is what I did.
Now, why would this prosecutor subpoena a willing participant? You're willing to come and testify about this man forcing you into prostitution, but you using the office for personal gain to subpoena.
The reason I elicited his wife's statements was effect on listeners. She's not here for this motion. Didn't need her to be.
Hold on. Didn't you just say you subpoenaed her?
You wouldn't have been able to subpoena me.
Yeah, I can subpoena you lawfully, which is what I did.
So you subpoenaed her, but then you went back and told Susan Tripp that you didn't need her?
The reason I elicited his wife's statements was effect on listeners. She's not here for this motion. Didn't need her to be.
Wow. And when we talk about the prosecutor having way too much discretion, this man had way too much discretion. Way too much. Normally I'll put his picture up there, and let me put his picture up there so y'all can see who I'm talking about. Because this man is fully corrupted. Full. He got potential to be going to jail for his unethical misconduct. He got a lot of explaining to do to the people. How many people did Douglas Hanson illegally prosecute? How many? I mean, this man is really dangerous. He's a dangerous DA. What makes him so dangerous is because he knows what go on in the DOJ. He knows what go on there. He's playing personal cards.
You'd like to tell me?
We don't want to play that video.
And since the Miranda begins so early in the contact, he did not sign the
A
Miranda.
prosecutor, knowing that Miranda wasn't signed, would say, I don't have a case. You didn't read this man his Miranda rights? He didn't sign Miranda warning? What are y'all doing? What are y'all doing? No, he wanted to prosecute me because he took it personal. Why did Douglas Hanson take it so personal? Why was he so into sticking it to me? Because he thought I hated homosexuals. Because I used a specific word, which I'm not going to say because I don't want to ruin this video. I used some specific words back in my Cashman Johnson days that he felt like I was basically racist towards homosexuals and the LGBTQ parties. Right, and that's far from the truth. I don't know what. So he went to a whole lot of people.
By my record, this case is going to go to trial. We all know that. This case is going to go to motions. We all know that. So let's all share information so that all that information gets on the record, if that's appropriate.
If that's appropriate, how is it that y'all get to go through the pre-trial motion part of it, but y'all don't take me through the trial stages? Because when you go through the pre-trial motion hearings, we want to proceed. What would have convinced Matthew Johnson? Because Douglas Hanson applied pressure to my wife. He applied wrongful pressure. He did wrongful things. He didn't give nobody a chance to fight. what he kept doing was going back to his constituent party lying. This is your work, Douglas Hanson. Take a look at this, right? And what we do is we just gonna leave Douglas Hanson picture up for the remaining of this video, and I'm just gonna use this side for paperwork, right?
As this court heard from Dr. Harbison,
As this
the
court,
metformin that Mr. Johnson was given did cause him nausea and perhaps some disorientation. Dr. Harbison testified that there were adverse effects to that prescription being given to Mr. Johnson when in fact he was not diabetic,
right?
and that prescription could interfere with his ability to cooperate and with his ability
Under
to make
duress,
rational decisions. We would suggest to the court that his vomiting in mid-interview was indicia of exactly the kind of symptoms that Dr. Harbison is talking about, and we would ask the court to suppress both the statements that he made as not voluntary.
And this is
as well
true.
as physical
This is
condition,
true.
and the search of
So I
his cell
can't
phone
give
based
Gail
on
Ryder
his physical
the
condition.
fact that she told the truth.
Even if she did tell the truth, she was outnumbered by Douglas Hanson and Susan Tripp, Mrs. Bench Trial, Mrs. Fact Finding Judge. She was playing right into Douglas Hanson's hand because Douglas Hanson behind the scenes told Susan Tripp all these made up lies and stories about me, how I hated gays and, prosecute me to the max. They never ever could send me to prison on this crap because it was made up lies. It was just straight up a hate crime. Period, point blank.
Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth?
I do, Your Honor.
Have a seat.
Thank you.
Once you're seated, state your entire name, spelling your entire name out for the record.
Yes, ma'am. My name is Detective Rogers Smith. My first name is Rogers. Last name is Smith.
Counsel. Thank you, Your Honor.
He already lying under oath. Roger Smith lying under oath. Let me explain to you why he's lying under oath, and we're gonna go to his own paperwork. This judge said, under penalty of perjury, state your entire name. As you can tell from his voice, you can hear that this officer is just shook up in it all. Like he's scared. Like he know what he doing is wrong. He told, but this is the thing. Douglas Hanson told him, "Don't worry about it. Don't worry. This fucker is going down." That's what he told Roger Smith about me. He didn't tell Roger Smith the truth. He didn't tell Roger Smith that I was a smart young man. Nah, I'm just a nigga that don't know nothing. I'm just a nigga like my grandfather said. They looking at me like I'm just a gorilla with a suit on. I'm out of a cage, right? But you see where it says, I, Roger Gerald Smith with the Salem Police Department. Let's go. Let's run this thing. And when you under oath, you actually supposed to be telling the truth. She said, state your entire name. You know your name. You know what your mama gave you, Mr. Gerald Smith. So let's run it back.
Under penalty of perjury, do you swear or affirm the information you're about to give in this court and cause shall be the truth?
No.
I do, Your Honor.
Have a seat.
Thank you.
Once you're seated, state your entire name, spelling
Entire
your
name.
entire name out for the record.
Spelling your entire name.
My name is Detective Rogers Smith.
Oh,
My
man,
first
he's
name
shaking.
is Rogers. Last name is Smith.
Thank you, Your Honor.
He's shaking. He know what he doing is wrong. You can just hear it in the transcript. He don't even want to tell the courts that his name is Roger Joe Smith, but behind the scenes, he's putting in affidavit and he's exercising Oregon revised statute codes when he not even a judge. It's in his own affidavit work. I am a police officer and a member of the Salem Police Department and authorized to make application for a search warrant under. So basically, he's saying he's got permission to get these illegal search warrants under this Oregon Revised Statute, where it clearly states in the Oregon Revised Statute 133.545 is that a judge have this saying to signing a search warrant. An officer can't sign the search warrant. You the one that's getting the evidence. Don't you think that's a bit of a contradiction? A bit of a hate crime going on there? You the same officer that went into the room and got all the evidence is now the one that's signing for search warrants. I've been employed as a police officer since January 26, 2006 to present time. I was previously assigned to the patrol division of the Salem Police Department from January 2006 to January 2014. In January 2014, I was assigned to Salem Police Department Street Crimes Unit. The Street Crimes Unit conduct narcotics and vice investigations involved in actively complaints and investigations involving drug endangering children. I presently hold an intermediate police certification for the Board of Public Safety and Standards and training. I have had all stages of police training, including crime scenes investigations, accusations and provisions of evidence, felony apprehension, search and seizures, and other police operations. I have reviewed formal training and the identification of controlled substances such as marijuana, cocaine, and morphine, heroin, as well as meth. Anyway, what I'm trying to tell you is that this man's name is Roger Gerald Smith.
So tell us then about the dealings with Mr. Johnson.
Mr. Johnson was, as I said, walked into the bathroom where Detective Hernandez spoke with him.
Hold on. What I want to do is I want to show you who Roger Smith is to, who Douglas Hanson is talking to in this moment. Why they just illegally trialing me, but they calling it pre-trial motion hearings, and they hide it. They hid out all the evidence so the Oregon Supreme Court can't see this. And that's the whole reason why I spend so much time going live, trying to get help on this, because there's no way a person should have to go through this much damage.
So tell us then about the dealings with Mr. Johnson.
Mr. Johnson was, as I said, walked into the bathroom where Detective Hernandez spoke with him. I really had very little interaction with him. Saw him briefly a few times as we were conducting the investigation. I did most of my talking with Ms. Johnson. And then after that initial interview, I actually had to work on most of the paperwork and writing up the arrest documents and things like that.
Did you ever have any conversations with the defendant?
No. No, you did not.
Briefly, I believe. At one point, I think when I was talking with Detective Hernandez, at one point there was Mr. Johnson said he had money in his shorts. And I think he was wearing like 2 pairs of shorts, and we had to go in and get the money from with his consent to remove the money.
Did you remember that, or was it Officer Hernandez?
If I remember correctly, sir, give me just one moment. I believe that was.
Give him just one moment. You got to look in your notes. Bad police
That
work.
was me, sir. And it was later found out to be $1,200.
$1,200 in cash?
Yes,
That was found on the defendant,
yes, sir.
Mr. Johnson.
Correct.
Do you see that defendant here today?
Yes, sir.
Can you point him out, please?
He's sitting right there.
So 2 from my left at council table.
Yes, sir.
And
Don't that sound like trial to you guys? It just sound like trial what this man is doing to me.
were you aware then that did your investigation include, in addition to the prostitution situation, any drug activity?
Yes,
Tell us about that.
I talked with Detective Hernandez
Uh-huh.
at one point after he'd been speaking with Mr. Johnson and learned that he had looked through with Mr. Johnson's consent his cellular phone.
That's a lie.
During those, or in doing that, there were text messages that were consistent with him.
Why is he testifying? What the reason
Also,
they
for
have
controlled substance,
Hernandez there
it's an
for?
illegal substance without a prescription.
Without a prescription.
Is it legal? If let's say you
Oh
actually have
no,
a
you
prescription
leading
yourself
a
for
witness,
those
Hanson.
pills, is it legal for you to then sell those to other people?
I never did.
And so let's tell us a little bit more then about the oxy and then the text messages.
The Detective Hernandez told me that there were text messages on
Not
his cell
the-
phone.
He told me.
that were consistent
What
with him
what is
reaching out
Hernandez
to
doing here
individuals
then?
saying that he had 50 oxys, 5 milligram oxys to sell, and was going to sell them for X amount of dollars. Which, when he told me that, I had noticed in the room there was a bottle labeled or prescribed to Mr. Johnson of 5 milligram oxys, and there were 50 of them within the bottle.
So that
Right.
physical description of what you found matched exactly with what the text messages said about selling 50 of the 5 milligrams.
Yes.
What?
All right, and talk about, if you can, Detective, the individual, or could you determine who he was talking
Oh
with
yeah.
in regards to trying to
Yeah.
sell these drugs?
Yeah.
A
Tell
gentleman
me
by the
that.
name of Nick.
My
was
power
one
of
the most
attorney.
commonly, the most common messages that were sent in that manner for about
Absolutely.
No, you should not be able to look into your
And while you were doing
notes.
that, Detective, looking to
You're
find some of that,
orchestrating this.
you did a whole scan and extraction of the cell phones, correct, to help you determine everything that was going back and forth between these people and who owned which phones?
Yes. On Mr. Johnson's phone, so the text messages in reference just to the oxycodone portion of it dated back to the 5th of May to mostly to a gentleman by the name of Nick. Several messages to Nick back and forth. At one point, Mr. Johnson sent this Nick a text saying that his sister needs bill money, and that she would have to sell them all. For
How if they
$250.
my prescribed medications? What my sister got to do with it?
All
They
50 of
lying.
them for $250.
Lying.
And the other gentleman was kind of haggling about the price, and that was the last messages were up to the 6th of May until the evening of May 15th.
Which proved I was not in
A message
Marion
was sent from
County.
Mr. Johnson's phone to Nick at about 7:44 p.m. Asking if he wants to buy some oxys, 5 mg, 50 of them for $200, which is actually a fairly good deal, since they're typically a dollar a milligram. 50
So
of
you
them would
see
be
where they said
between $50
$7.55. I
$50
was
potentially
texting Nick in Multnomah County, not Marion County.
And so he sent that message to this Nick on the evening of May 15th. And then that was the last message regarding the oxycodone.
But I got arrested May 16th. You see that? I got these people all trapped up.
Detective, I want to go back a little bit then to text messages that were sent between Miss Johnson and the defendants in regards to the prostitution aspect of it. Did she go by the nickname of, or on the phone, Queen Moneymaker?
Yes, sir.
And were there very
I thought it was
messages sent
Colina
between she and the defendants in regards to the meetup with you?
Lying.
I think one of them said, I hit a lick for $100.
Yes, sir. There was. Let me look at the message specifically in regards to literally thousands of messages. And when I wrote my report from that analysis, I took small snippets.
You took small snippets?
Trying to get them all.
Nah, that ain't how court work, buddy.
A sample of these are from Queen Moneymaker.
That's a lie.
So he made
listed there is the
a list,
which I
and he
called,
put
from
text
the back
messages
page
together,
on May 15th and May 16th.
which made sense to him trying to make me be my wife's pimp, and it's illegal.
Things such as I hit a lick for 100. A lick is a more common slang term for a robbery victim, but in this sense, it would appear that they're kind of using it for their own as like a John or a client in this sense.
You hear this man just crucifying? I don't even know who Roger Smith is. What is this dude doing testifying in the pretrial motion hearings if my wife took an EDP off her, or early dispositional program, for lack of evidence and lack of information?
Did you receive information in talking with Ms. Johnson then and looking through her cell phone and seeing the messages she sent to the defendant? Did you then question her about the defendant's knowledge of what she was doing in his role?
I did.
And what did she say?
She was very vague on a lot of those comments, but she would eventually kind of open up that he is there as a protection. They had a prearranged code signal or code word, such as when a client would get too rough with her, she would say no 3 times, and that was Mr. Johnson's.
This is far from the truth.
He was hiding via closet.
Why would any man wait to hear no 3
Ms. Johnson
times
denied that there was anything physical
to help his
that happened
wife?
between Mr.
This is
Johnson and
just slander from this officer right here. He never ever talked to me. Roger Gerald Smith. You hear he stuttered on his own name. She said, state your whole exact name. And he only gave her Roger Smith. His real name is Roger Gerald Smith, for the record.
He's never had to hurt anyone.
I never had to hurt no one. Listen to this man. Listen to this slander. They got somebody else's background on me. And I ain't do nothing wrong.
He drives her to local stores to buy debit cards, prepaid debit cards, because they don't want to keep their cash on hand.
So how did you get $1,290?
If that's the case, then how did he use the $1,200 that he found in my pockets? How? If we put it on our debit cards, they never seized our debit cards. They only took my money. They robbed me of my money, which came from my lawsuit.
For that, how did you describe that?
Why do he always got to go back into his notes? He should have been ready for this.
She said that the money was shared.
The money was shared how?
She doesn't, quote unquote, pay her husband, but the money that they earn is shared.
She don't pay me.
According to her.
These people slander me so hard, I don't even know what to do. There was no fight in my side of the court because Gil Ryder felt like I was a pimp anyway.
Was there for protection, intimidation, and also get some of the proceeds.
How, when I was extremely sick at the time, there was no way I could have helped my wife.
She had no cash on hand. The only cash that we found was in Mr. Johnson.
So I'm guilty. I'm not allowed to have no cash.
Is it of significance that you found $1,200 on the defendant for your
Actually, it was $1,290 according to the police report.
The night before she had met with two other individuals.
They talk about the $1,200, but they forget I had $1,290. So my question is, where is the $1,290? Where is the 90?
Per person, that'd be about $800. She said she'd met with at least 2 people. So
technically, Officer Roger Smith offered Mrs. Johnson a $50 extra for not being there on time. So this is a lie what he explaining.
And that was all in the possession of this defendant, not Miss Johnson.
That's correct.
This is complete.
They put all the evidence on me, just lying. So now what we're going to do is get rid of you, buddy, and bring up your friend. Your friend had to come up and testify too, because y'all took me through trial. And y'all think y'all going to get away with it. Eric Hernandez also with the Salem Police Department.
Interesting.
They
You did
stories
state your
contradict.
entire name and spell your entire name.
My name is Eric Hernandez, and Eric Hernandez is spelled ERICK HERNANDEZ.
Okay.
So you know, that's him. That's what he looked like to me when he supposedly found my phone in my pocket. One found it in my hand, but he claimed he found it in my pocket. These fools is lying all over the place.
Tell us then, did you assist in the investigation that took place on May 16th of 2014 involving Matthew Mayfield Johnson Jr.?
I did.
Tell us about your role, please.
My role was basically to assist detectives, primary detective working that case. My involvement really didn't begin until the actual execution of the operation, where Detective Smith engaged in or set up basically what we would consider a sting, in which he made contact with a Jessica Johnson, basically in answer to a Backpage ad, an internet website advertisement, and so that initial contact, I should say, basically occurred at the Shiloh and Suites located at 3
They stutter a whole lot.
Salem, Oregon,
A whole lot.
Right. And so, tell us, Detective, then, were you one of the officers that had entered that hotel room that day?
I was.
And
Yes,
tell us
he
about
was.
your contact with the defendant.
So initially, Detective Smith approached the front door of the room, and after knocking, the door was answered by Miss Johnson. And if I remember correctly, she was wearing a pink.
If he remember correctly, he know.
Underwear. That was about it. There wasn't really much that she was wearing at that point.
So why frisk her down in front of her husband? Why touch and grope my wife?
And we made entry into the room. After Detective Smith contacted Miss Johnson,
They the ones that
Detective Dee began
committed
to
the
check
crime.
the remaining rooms that were in there, which was basically a bathroom and then a small closet.
The closet
As
wasn't
Detective
small
Dee was
at all.
looking in the closet, he immediately yelled, "Show me your hands, show me your hands." And that was obviously a clear indication to me that there was somebody else in the room. Detective Dee drew his gun, and as did I. And
Right here in
directed
my
our officer
face.
our point of fire to the closet, and Detective Dee ended up giving commands for
Fear.
Mr. Johnson to step out of the closet.
What
which he
would a
did.
black
But,
man do
after that,
when
he
the
was
police is already killing all of us? What?
They're on the floor in the middle.
What?
And do you see the defendant here today?
I do.
Of course they see him. I'm not the perpetrator,
Yes.
they are.
Can you tell us, Detective, you said you drew your weapon, so you had your weapon on you.
I did.
Were you in plain clothes or in uniform?
At that point, I was in plain clothes, but I was wearing a ballistic vest underneath, and I did have my badge. Generally, when we do these types of investigations, we approach the location in plain clothes with nothing visible. But as soon as we get to the point where we are actually going to identify ourselves as police, we'll make our badge visible either by a neck chain or just on our belt.
So was it visible on this particular occasion when you had
I believe it was.
contact with the defendant?
I believe it was.
And in telling the defendant, getting him down at gunpoint and handcuffing him, you said that you told him he was under arrest.
Correct.
And you signified you were a police officer.
I did.
And what did you do next with the defendant?
At that point, I separated him from Miss Johnson. I actually escorted him into the bathroom, which was just to the right of the entry door. So a small bathroom just in the room.
How long were you guys there, and what did you do?
At that point, I advised him of his Miranda rights first thing. And after doing that, I'd say I probably spent at minimum half an hour with him in the
You
bathroom.
read me my Miranda rights.
I advised him of his Miranda rights.
You're
right away,
lying.
and I basically began an interview with him.
Did he
Out of fear,
understand
you
his
put
Miranda
me in
rights?
He stated he
handcuffs.
understood his Miranda rights.
You
and he
wasn't,
had no
your
questions.
mind wasn't
Did
on
you have him
Miranda
sign
rights,
a Miranda
Hernandez.
rights
Because out
No,
of fear,
for the-
you
for the
put
Miranda rights, he did not
me
sign
being
a
in the
card
closet,
at that
you
point because
was
he
focused on what kind of criminal I was,
basically
right?
one of the first things we do when we come in contact with someone. And since he was in handcuffs and he was hiding in a closet,
I wasn't hiding. I put my hands out when they knocked on the door and arrested my wife. I was already revealed.
Officer safety concern, and he was going to be cooperative. And since the Miranda begins so early in the contact, he did not sign the Miranda card itself.
No, I
And that's
did
because he
not.
wasn't able to with his hands.
No, it's because I wasn't aware of a Miranda.
One, and can you identify that for us, please? And I do have some scissors here, and I'll ask you to actually open that up, and we can pull out the contents as well. Sure.
This man is really ill, man. He's sick for
Yes, so
trying
this
to
is
cover
the Miranda card here
For
that I read to Mr.
Smith.
Johnson, and indicating the date.
Watch how he
the time,
testified
my
to his
signature
own
is on the bottom
lies.
line. And there is no signature on that second line, but it does indicate handcuffed.
And is that typical that you
He
would
wrote
write
handcuffed
in on the
because he
signature
didn't have my signature.
handcuffed and unable to sign?
That's lies. They don't got no place
And
doing
you said that he did
that to
verbally
me.
acknowledge his rights then.
He did.
No, I didn't.
During
I
your
was too
visit
sick,
with him for
throwing
approximately
up,
half hour
ill.
in that bathroom,
Correct.
and after reading Miranda rights, you had questioned him and talked to him about a lot of the investigation, correct?
I did.
At any time during that conversation, did the defendant complain of pain or discomfort,
Yes.
anything like that?
Yes.
No, actually, contrary to that, I remember asking him a series of questions, and I remember him actually.
All this in
distinctly
30 minutes.
Distinctly remember him actually laughing at some of my questions as if
Why would I laugh?
comical into how I was asking them. The only thing I do remember him asking, or basically complaining about, was thirst. He said he was thirsty at one point, which I provided him.
Which is a symptom of the metformin pill that I was taking. That's one of the symptoms that I was needing water or something.
Discomfort and pain specifically, no. At one point during the interview, and it was very spontaneous and random, I remember having to act quickly so that I could allow him to do so. But he was seated on the toilet in the bathroom, and just at one point, kind of randomly, he said, "I think I'm gonna throw up." And so
I never said I think I'm gonna throw up. I just threw up because I couldn't hold it no more. I just threw up and they all rushed the bathroom. That's the
Did he
truth.
ever tell you that he was on any kind of medication that was?
Yes, I did, because it all was on the counter. Don't you remember I had a medicine bag, a black medicine bag? It had all my medicine
He
in
was
it.
in, not talking about medicine particularly, but just saying, I'm really not feeling right, I'm not understanding you, or I really can't communicate very well with you.
After he vomited, he told me that he had, and I'm sorry, I don't remember what the condition was, but after he vomited, he told me that he had a specific condition and that this was common for him to vomit and not to be able to keep food down.
I don't have no
But nothing
condition.
about
I don't
understanding
randomly throw
No.
up. I was
During
taking a
communication with the
metformin
defendant,
pill that had me throwing up.
Was it
And I had no
any time at
control
all
of
that
it
you felt
because
he
I
was not
thought
understanding
that
you,
my
or you were
doctor
not understanding him?
No.
said I was a diabetic. And it was wrong.
So let's go through then, after you had read
Look at this
Miranda
slander.
rights,
This has hurt my heart every time I
did you
listen
talk to
to
him
it.
and
But I gotta be
about
strong
why he
enough
was
for
there and
God
contact with Ms. Johnson,
to do
how he
God's
worked?
work.
I did.
Can you tell us about that, please?
Initially, I asked him what he and Miss Johnson were doing there at the location, and he indicated to me that they were on their honeymoon.
Now, why would I say I'm on my honeymoon
I
when I know exactly
basically kind of asked
the
him,
difference between a
what
honeymoon
he was
and a
planning as
rendezvous?
being there. And,
That's like saying I'm stupid. I don't know when I married my wife.
initially told me that he didn't really know what I meant by what his role. I asked him. I after, like you said, basically explaining the investigation and why we were there. I asked him to tell me how he might be involved in Miss Johnson's prostitution activity. he kind of laughed at my questioning, and I remember specifically saying, he said, "I see what you're doing. You're trying to get me to say I'm doing something."
And I wanted to see a lawyer immediately.
Basically told him
He left that part out.
Be honest about what was going on at that point.
He still
and I
forced
asked
the
him why
interview.
exactly he was hiding in the closet. His response to me at that point was, quote, "All right, I'm going to be straight with you. I hoe too. We hoe too."
So why do I got promoted prostitution if I told him that I hoe with her? It doesn't make sense. They lying. But I got promoted prostitution.
That he replied, and I quote, "I mean, I suck and I fuck with her."
See how he reading off his notes?
If he was specifically
Stuttering still.
engaged in sexual activity with Miss Johnson in exchange for money or other types of payments, and he said, "Yeah."
All right. And did you talk to him about, other than just the two of them in this agreement, were there others involved, and what his role was?
Yes, so basically the way he explained how some of these arrangements would work, he said that if somebody wanted to, engage in sexual activity,
Why they keep saying I guess?
he would be
These
a part
people
of that
is
deal. They would not
weird.
know that he was a part of that deal until they actually reached the location. And I asked him if he meant to tell me that if someone agreed upon those sexual services, that he just included him in the service.
This is him
without telling them prior.
testifying on
Yes.
the fact that I'm a supposed prostitute. Nothing to do with promoting it. You get what I'm saying? It's like they don't know what
Miss Johnson never actually
they talking about, but they charged me with promoting prostitution and delivery of an oxycodone, and I never did either one.
And he said when they show up is when he explains. And I asked him how that usually goes over with the person that shows up expecting to meet with a young lady and then realizing that he was there as well. He said, "We are all consenting adults and it's just casual fun." That was his explanation and reasoning behind that. I asked him if anyone actually agreed to this once arriving at the location and knowing that Mr. Johnson was going to include himself in the activities. He said yes, and if they don't feel like they were going to include themselves, that they would just sometimes watch. That would be part of the agreement at that point.
Boo! That's a lie. That's a lie. I told him that me and my wife had contracts.
As far as the agreements, and for some reason he said that they didn't want
doing
to
webcam.
Include themselves, that they would just.
I told him that me and my wife does webcam. That's exactly what I told him. And you can find that information located on Kerry Wyman's notes.
Notice that there was a phone that the defendant had at this time?
Watch this. Watch this.
And,
this is where they stories mix up at.
If I remember correctly, he had it in the pocket.
Oh, but Roger Smith said he picked it up off the floor.
I did.
He said it was in my pocket.
I asked him if I could look through his cell phone, and his response was, "Go ahead, you can look through whatever you want." So at that point, I read Mr. Johnson, the department issued.
Again? Come on, you gonna read it to me again and I not sign it?
Allowing us, or asking for his consent to search.
This is illegal. This is fruit of the poisonous tree. This is a federal law that they are breaking.
Prior to
right here and right now.
Initiating my entire interview with
Watch how he testified to how he just quickly forget that he need my signature. And this room was never shared between me and my wife. It was in my wife's
He
name.
agreed to allow us to search the room and the possessions that were there. So this was actually the second time that I had read the consent search card to him. So he agreed to the consent search. I actually, at this point, removed him from handcuffs.
Wow, what do you know?
And why now at this juncture?
Yeah, why now? Why?
For the phone,
And look at the poor lame excuse they give.
I had spent significant time with him talking about
seeing how sick I was and how hard I was rocking and how fast my heart was beating. That's what you was witnessing.
Offensive.
Tell the truth, Roger Smith. Hernandez. Tell the truth.
Not necessarily to be a threat, so I felt safe at that point for my safety.
Both of y'all lied.
To allow him to say.
So that at that
Right.
you did have him sign that as
I
well?
did.
Is that part of Exhibit 1 that I handed you?
Yes, it is.
And can you describe for us then on that card, did he sign that and did you sign that?
I did. So he signed it. Well, you can see on the first line where his signature would be. The initial portion of it says yes.
How did
which I
this
wrote.
judge
that
let them get away with so much wrong?
And then right next to it,
Was she
his
really
signature.
in cahoots with the whole
And then
plan and
My
plot?
name is listed at the bottom.
Maybe it was because they knew I could sue
Your
them
Honor, this
for
time I would offer case exhibit 1.
what they done to me. They made me do 22 days with no PO.
Yes, please. Yeah, let me.
22 days with no PO, no sanction. I did sick. I was stopped from being seen from my
I'm
doctors
sorry,
to
there's
see
a
what's
second one here
wrong
for
with
Miss
me.
Johnson.
They used my wife evidence that they charged her with against me in my criminal case. That's crazy. It just says room and car. Like I said, they only asked me to search my car, and I don't know how they wrote room on there because the room was never shared with me and my wife.
Yes.
My wife
Thank you.
got that room on her
This
own.
particular one that the defendant had signed, it says room and car here.
Correct. So that
Why
would
wasn't
be
this
the
case
first
dismissed
reading
then?
of the consent to search.
How did that information get past a judge that studied her whole life?
But I did
Listen
fail
to this
write
mess. This mess is just all over the
open area,
place.
I guess, in that card.
This top portion says
They can't take it back now.
premises that you're allowed to search.
I need justice.
That's right.
I need help from the public.
Right, the second time, yes. And that's when I signed.
So the
You
first
gotta
time
listen
it's
to
time
these
when
deep,
handcuffs
deep,
are
deep,
broken,
deep
card,
thoughts of
you can
mine.
search all this.
That's
Somebody out there gonna hear.
Yes, quote, yes. And he
Listen
decided
to
say
this.
That was for his cell phone.
Well, I wrote yes after the initial reading for the room and card because he wasn't there to sign. And then during the second portion, when I read it the second
The
time,
baby hungry?
that's when I removed the handcuffs, and he was able to write or to sign the card himself. But I didn't write specifically cell phone or anything on any of the free space that's might be
Just all
remaining.
inclusive.
That
Correct.
show that's his
Why?
So detective, so that
Yes.
I'm sure I'm clear, you use the same card twice.
He used the
Yes.
same card twice
Yes.
for two different things.
No objection to it, states exhibit 1.
Cause she didn't want to
Objection.
help me. So she let it ride.
Fuck that. Objection.
She could have ate that up and man, I'm
Man.
telling you, a real lawyer would have ate that moment up right there. That's unethical to do. You gave me an interview for approximately 30 minutes and you still chose to break the law. You broke the fruit of the poisonous tree.
Thank you, Your Honor. So Detective Johnson,
Not
excuse me,
Detective
He called me
Johnson.
Detective
Ask Mr.
Johnson.
Johnson then,
You're
Call
right.
me Detective
if he
Johnson.
could provide you the passcode to actually access his phone.
Yes, I did.
This
This
is a lie.
When
My
began
phone
to
was in
install it, it was
passcode
protected. So I asked him
This
if
is
he would
lies.
provide me that passcode so that I could actually review.
My mama can get into my phone.
And he did. He verbally provided me the code 0550.
I don't even know what
Punch
that.
in.
I don't know what
Did it
that
access his
goes to.
phone?
Yes, it did.
And again, you only knew that from the defendant telling you what it was, correct?
That's correct.
And
So were you able to then look at text messages on that phone?
I was. I reviewed several messages. One contact in particular reviewed messages from a contact listed as Moneymaker. After looking through the contact listing, I saw an associated photo with that contact, as many cell phones will allow you to do now, and I recognized the photo of the person to be Miss Johnson.
The same Miss Johnson that Detective Smith had made these arrangements with.
Yes, that's correct. During the
Smith
text
made
message
his
conversations that I
arrangements
reviewed
with.
between Mr. Johnson and Miss Johnson, Miss Johnson made reference, several references to
look
having
at him stuttering.
quote, a lick. And in my experience and training experience based on human trafficking and prostitution type investigations, I know that term is common for referring to a John or a subject engaging in soliciting prostitution. So somebody that the
Now
person
this is
planning on
him
meeting with.
testifying to me being a pimp. But earlier he testified to me being a prostitute.
Was he listed as quote P, the letter P?
Where's this
I
information
did
at?
read several text messages where he had actually referenced himself as P, just the letter P.
That could mean punk, pussy, anything. But they called it pimp.
in these types of investigations,
This is
I know
wrong.
the letter
This
C
is
to be
real
short,
slander.
a way basically to commonly refer to someone's self as a pimp. And I specifically asked Mr. Johnson why he was referring to himself as P in his text messages.
What did he respond?
His reply was, all right, I'm going to be straight with you.
Again, I said that twice. I said that, all right, I'm going to be straight with you. See how it's all just written out like,
how exactly he
no,
portrays himself to
I don't
be a
even
pimp.
talk like that.
And he just said, like on Facebook and stuff, I just do it because that's what people expect.
Nobody expect that of me. Nobody.
In reviewing more of those text
Nobody, I
messages
repeat.
That were on the defendant's phone, did you come across any indications of drug activity?
I did. I came across another text message conversation where I found an outgoing text message where he told the recipient of that message that he had 50 oxy pills for sale for $200. And later, after talking to Detective Smith, I learned that there was actually a prescription bottle in the room that contained 50 oxy pills.
All right. Based on that contact with the defendant, then, did you arrest him and charge him with prostitution, compelling him with the delivery of the oxy pills?
He said compelling.
You know, this was all.
Where's the children at in the compelling?
And
You see that?
from Detective Smith, this was also in
Slander.
1,000 feet
Call
of
me a compeller.
elementary or vocational school in Marion.
That's correct.
Lastly, Detective Hernandez, when you arrested him and took him in, did you end up taking him to the hospital?
I specifically did not transport him anywhere. Because of our location and kind of how our team sets up these operations, we're generally not able to conduct transports, so a patrol officer will respond to the location and conduct our transports.
Is that because you're typically in plain clothes and unmarked vehicles?
Correct.
So you don't want him transported by an actual marked vehicle with an officer in uniform?
Right, correct.
And again, anything unusual about the contact you had with the defendant where he wasn't understanding you or any of the questions or things you found?
No, at no point do I feel like he couldn't understand me or like he didn't. It was very clear that he understood what I was saying and I understood him.
Thank you, nothing further.
I shut the whole house down, everybody down.
Not me.
I said, ooh, this little girl, she cold.
It's the only time I can clean up without saying move.
She took the whole house down, that's a powerful child. Took everybody's energy and locked me inside, I'm hungry. I knew I was tired. I knew I was tired.
1 minute.
Wow, straight slander.
Cups
She like
faster than my time.
the judge asked to look at the consigned consent cards. She should have threw the case out.
Hernandez, you have no idea where Mr. Johnson was, or if it was Mr. Johnson that sent the text messages from his phone, do you?
No, obviously I did not watch the.
Right. So why why am I charged this
And
way?
with regard, do you know that he was in fact transported to the hospital on the way to the jail?
I was informed of this later.
Okay. But
They
you
knew
didn't
because
do
I
that.
was sick.
No, I didn't.
Trust me.
That it's somewhat unusual for a person to be transported to the hospital before being taken to the jail, isn't it?
I think more so nowadays it's becoming much more usual because of that. Not because of the person's condition, but because of the jail policies.
Okay, but if there's any concern at all about a person's physical condition, they need to be checked at the hospital.
Correct, yeah. It could be depending on use of force, like specifically if we use a taser, that person
Which
needs to be
didn't
checked by a
happen.
professional. Not that it's
Sure.
life-threatening or that their physical condition is that they're unable to do anything or they may be just fine, but it's just because of that policy they are required to be evaluated first. So,
But in this case, when he was brought out of the closet to use that turn of phrase. You wouldn't say it was
You hear the
excessive
laugh
force.
in the back?
Oh, no, definitely not.
And in fact, although guns were drawn, and I guess this is
Poor
obvious
black
from
man
his
scared
point,
of
but
the
nobody
police.
shot at him,
That's
right?
correct.
Okay,
I
and
would've
nobody
hid
used their
too.
taser.
Correct.
Just like I do.
He did throw up when you were talking to him?
He did, yes.
Why would I just throw up and throw up for like 2 or 3 minutes?
Yeah, I specifically remember him saying that was a common thing for his condition.
I never said that. I never ever said that because I didn't know I had a condition. I thought that I was a diabetic.
I think you missed it there.
So what condition that I had me throwing up, lying, cheating my medical.
Cross-exam.
Watch nothing.
Thank you, Your Honor.
Listen to this fake. She's a
Yeah.
fake. I repeat, Gail M. Ryder is a
Sorry,
fake.
I'm fighting with allergies.
No, she wasn't. She just didn't want to help
You
me.
actually don't know, though, you don't have any information about who was operating or editing that back.
No, they don't. No, they don't.
Could have been anybody.
So why would you blame me? Why would you say it's my computer, Officer Roger Smith?
Offering to sell the oxycodone on May 16th.
No, there wasn't.
May 16th.
No. So how did I get charged?
Actual arrest of Mr. Johnson.
And why was my motions denied?
No, sir. Or, excuse me, ma'am, I did.
That's right, I get that a lot.
I apologize.
No problem. Okay. So you don't know where he was transported after he left?
And I told him I was sick. They rushed the bathroom because I was throwing up. Was he? He knew I was sick because he took me in the elevator and I told him I was sick. This is ridiculous. Really ridiculous.
Are you the person who found the oxycodone?
Yes, he was. Look what he
I don't
said.
remember if I did find it. I should.
Why? You the leading detective, Roger Smith. You the leading detective, and you gotta look back into your notes. Didn't you write that you found it in Jessica's purse on your police report? How can you forget that so fast? This how I know they hate me, and this judge let them get away with looking at their notes. But I couldn't produce none of my evidence.
Thank you. You may step down.
I've never seen anybody in court use their paperwork to tell a story.
Say what?
I've never known in court, even on TV, that, what's that,
Oh no, I gotta get it up before hands come.
sticky?
You never known what?
I've never known anybody that be on court able to use paperwork and recite the paper. Normally you have to get on there and take an oath that you're telling the truth. And you ain't got no paperwork notes to be off of.
May I refer back to my
They don't even
report?
do that even in the TV.
They was cheating. That's what they was doing. He was letting them look at evidence that wasn't even real evidence.
It wasn't even, and then you try to say that you sneezed because of evidence. No, you knew this shit was bullshit.
Yeah, he switched it up. You cheated. You didn't even question the doctor. You sent somebody else in to do that.
And the question she asked was so stupid.
Who, Gail Ryder's? She danced around my medical because she knew I went to the hospital sick and dying. What happened was they questioned me under duress, and they think I don't know that. You can't question me under duress, and I'm sick and I'm dying. Give me some medical attention. Figure out why I'm throwing up mid-interview. Figure that out. Figure out why I'm throwing up. Y'all just wanted to charge me.
That laptop was identified as Mr. Johnson's.
They said that laptop was mine when they knowingly knew it was yours.
He said they were supposed to identify it as.
Yeah, but Gail Ryder said she already cross-examined him, and he already admitted that he didn't know it was mine.
And when you're in the edit mode, whoever's doing that, placing the ad, that is typing it and doing what they want.
They just put everything on me.
That was,
but they still charged you.
Screenshot showed that the ad was being done.
People can't even fathom what I go through
So
in
5
my
p.m.
everyday life because of this.
So 5
That's the ad
p.m.
involving
May
Jessica
15th.
Johnson.
Yes,
But Susan Tripp said at least there's evidence of me not even being there on that day. They stories is just jacked up lies.
That's why.
So at least there was evidence
It was evidence.
that she was in Salem.
Yeah, that's it. That she was.
The 15th.
Now
Yes.
listen to
She
this.
indicated as such in that ad that she had placed.
They said you placed it, but Roger Smith lied and said it was my laptop. It was me. But the judge saying I wasn't even there. Come on, man. Come on, they lying.
So then tell us about how you, when you first physically met Miss Johnson in the hotel room.
Walked up to room 319 and knocked on the door.
Lie again. He said he walked up to room 319. I thought it was 419.
I know it
It was 419. Douglas Hanson said it over and over and over again.
So then
How
how
would
did the
you?
officers get it wrong?
And they been lying under oath the whole time.
These room number 419.
See,
which is
Douglas
within
Hanson
Marion
saying
County.
419, but his officer is saying
So then
319.
tell us about how you, when you first physically met Miss Johnson in the hotel room.
Walked up to room 319 and knocked on the door.
And I swear 319 was the room that the hotel gave to them.
I believe there was also a cell phone that I didn't find it personally. From what I was told, it was found in his hand. I believe at the time he was taken into custody.
Officer Hernandez would have that information.
Yes, sir.
Lies.
Taking on Kerry Wyman's
notice that
notes.
there was a phone that the defendant had at this time?
Watch this. Watch this. This is where they stories mix up at.
If I remember correctly, he had it in the pocket.
Do they ever use any of the transcripts?
No, they don't use none of it. They blocked it.
No, he blocked it.
They blocked it.
No,
No, none of the transcripts is there for
I
the
get it.
courts of
I
appeal.
get it. While you was going through the courts, he knew you was going to appeal because you busted Gail Ryder, and in the course of the last day said, well, that's not what she had told me. So he knew that. That's what he said, well, I don't do PCR, blase. When you was out posting these videos, when you first started to do it, you was pinpointing all the technicalities for him. So he was able to block and stipulate on the audios
He covered it.
the evidence. He covered all
He covered
evidence.
it all up. He covered it all up. Saying that I stipulated.
No.
But really I didn't.
No, he tried to put stipulate on everything to cover his tracks. Because now that you're going back and listening to it, you pinpoint every single technicality that they did wrong.
Every one of them.
So it was easy for him to go back and cover.
Mm-hmm.
He didn't stipulate it on the case. He really stipulated illegally the audios, the transcripts.
To cheat me out of the appeal, to say that I'll lose the appeal so he can say, I told you so. Well, he covered it. He cheated the appeal. He cheated me on my appeal. And I kept getting denied when I've been telling the truth. I never stipulated. Gail Ryder told me I can appeal because Kerry Wyland took away my preliminary hearing. She told me that. She did. And then he used the judge that seen my PCR case. So he denied it. He denied it.
Well, it sounds like coercion. I mean,
It could be coercion.
gosh,
He
that is so foul.
Let's
The
listen.
judge-
Let's listen to that.
The judge
Let's-
admitted it.
Let's listen to that real quick.
Like the judge admits that it was coercion.
Yeah. He
He
admitted.
admits that this has been manipulated. What? And you allow it to proceed? Oh, you should never be a judge. You should be just dishonored.
Listen to this. Finna play.
Oh, baby, come here, think about it.
Who is that?
My twin. Look, she done got him. You hungry?
It won't play it for some reason.
Oh, and you guess he manipulated that track.
No.
Sit down so you wake up all the way. Okay, go get your blanket. She was.
It ain't gonna let me play it. I don't know why it's not letting me play it.
You don't have to this shit.
Something.
You did. You know you did.
It should let me play it.
They played it before?
Yeah.
I'm just saying.
He cheated me, man. That's why he left the Marion County DA's office. I don't do PCR, of course. If he have claims, he didn't object to none of them. Like all the stuff he did was wrong to me. Somebody gonna bust him. I stream his picture all day long, all day.
Are you hungry, Steve? I think that you independent. You not nobody helping you.
Ew.
Y'all could smell the candles outside when the door.
Mm-hmm.
It smells good. And plus the bath stuff. It all mixed in and there's just aromatherapy.
You right.
Huh?
You right. This dude did something to this. But one thing I know. One thing that I do know is that I control the master key to it all. That's what people don't get with this fool. Is that he's so vindictive.
No, he's evil.
He hella evil. He don't want us to have nothing that's gonna catch his ass up.
He caught himself up.
Yeah, because he started playing around with me. And he was telling people.
No, he caught himself up because he knew we recorded him for almost 2 hours.
That too.
It doesn't get any better than the fact that you have a video of the DA incriminating himself.
I don't understand. It's not clear.
Let us begin. This is case number 18 CV 17382. This is a trial, post-conviction petition
Lying.
And both counsel and petitioner are present in the Marion County courtroom. I am appearing by video, and I can see the witness chair in the Marion County courtroom. And I've had an opportunity to review the memos and exhibits that have been put forward. Let me ask Mr. Patterson, I see that you have, is it 1 through 14, or help me with your exhibits?
Yeah, petitioner would offer exhibits 1 through 14 at this time, Your Honor.
Is there any objection?
None, Your Honor. Choose to call me instead of
All right, I will receive petitioner's exhibits 1 through 14. And then I saw one exhibit for the state, which is 101, but there are a lot of pages attached to that.
So
I think it's something
exhibit.
like 78 pages or so.
Wow.
That's correct.
It's crazy.
Okay, and so you're offering that one exhibit?
One
That is correct,
exhibit.
Your Honor. State offers that at this time.
Okay. Okay, is there any objection to 101?
No objection, Your Honor.
Remember what he said? You wanted.
All right. I will receive defendant's 101. Is it anticipated that there would be any testimony today?
Yes, Your Honor. We'll be calling Matthew Johnson Jr. as a witness. That's it.
Okay. Will the
they use your
defense be
declaration
calling any
letter. They was
witnesses?
just lying.
Your Honor,
to
we
us.
will not.
He was working with them.
All right. Thank you. So we are at the point where
They did that
I've
to
received
just
all
discredit.
the exhibits as evidence, and so those are in the record and available now. But we also are going to have Mr. Johnson testify. So I'm going to need Mr. Johnson, if you would walk up to the witness chair, please. And when you get up there, I want you to raise your right hand, and I'll give you an oath to tell the truth. All right, Mr. Johnson, under penalty of perjury, do you solemnly swear or affirm that the testimony you will give today in this hearing shall be the truth and nothing but the truth?
Yes.
All right, please be seated. And we'll have you start out by saying your name for the record and spelling your last name.
Matthew Mayfield Johnson Jr. Johnsson.
All right. Thank you very much. And now, Mr. Patterson, you may ask questions.
Thank you, Your Honor. Mr. Johnson, were you listed as the defendant in Marion County Court Case Number 14C42686?
Yes.
And what were you charged with in that case?
Unlawful delivery of an oxycodone within 1,000 feet of a school and promoting prostitution.
And in this post-conviction case, are you challenging the constitutionality of those convictions?
Yes.
Were you represented by counsel at the time of the underlying convictions?
Yes.
And how many counsel were you represented by?
About 5 or 6 of them.
Who was the last one in that chain of counsel?
Gail M. Ryder.
And during Ms. Ryder's representation of you, did you have a chance to meet with her face-to-face?
No. Well, can you rephrase that? Because I met with her initially when she was initially appointed to me.
Okay, so
To be exact, I had one office visit with her.
one office visit. What about after that? Did you ever meet with her again?
No.
How did you communicate with Ms. Ryder?
Through emails.
And how did that come about? Why were you only communicating through emails?
She stated that she didn't trust me and that I wasn't honest with her in our meetings, and she just felt like she couldn't work with me.
Did you feel throughout her representation that you were able to promptly get a hold of her?
No.
And upon meeting with Ms. Ryder, how did you tell her you wanted to resolve your case?
I told her right when she was appointed to me that I wanted to go to trial.
And did you guys start marching towards trial?
Well, at least I thought I was. That's what was said to me in the emails, is that she was preparing for me to go to trial.
And communicating through email with Ms. Ryder, did you feel as though you were understanding the things that she was explaining to you?
No, absolutely not. There was a lot of confusion and contradicting things that were said between the emails.
And you have the exhibits in front of you?
Yes, I do.
Attached to your trial memo. Can you look at Petitioner's Exhibit 13, please? Tell me when you're there.
I'm there.
You recognize that document?
Yeah, this is a document from David N. Sweet, a doctor, which Gail Ryder had sent me to.
So did you have a meeting with Mr. Sweet?
Yes, I did.
Is that the report that you generated as a result of that meeting?
Yes, it is.
Are you familiar, or can you flip to Petitioner's Exhibit 11 for me, please?
What you want, another 1450?
It's backwards, sorry. You say 11?
Yeah.
All right.
Watch how the DA side try to contradict me.
There?
Yes.
You recognize that document?
Yes, I do.
Have you read the contents of that document?
Yes, I have.
Did you, at the time of your underlying trial, were you able to have contact with your wife, Jessica Johnson?
No, I was not.
Were you aware of the contents of that declaration during the underlying proceedings of trial?
No, I was not aware of it.
Did you understand how that content could be used as a defense in the underlying trial?
No, absolutely not.
And Mr. Johnson, did you and Ms. Ryder ever discuss uniform criminal jury instructions?
She sent it to me in email, and that was it. She never made a phone call to discuss it or anything. And my understanding at the time was because the emails was coming so frequently that anybody could have sent the email. So I wasn't really understanding why she never allowed me to meet up with her to talk about the actual jury.
So did you understand the possible jury instructions that could be presented at trial based on those email communications?
No.
How did you ultimately resolve your case, Mr. Johnson?
I eventually took a no contest plea. I just gave up, and it had streamed along for so long that I felt like I was bagged in a corner. So.
And what was your understanding at the time that you pled in regards to your right to appeal?
Well, as a part of my agreement with Gail Ryder, we had a conversation in a hallway where I asked her about the motions that my previous attorney, David Kuhn, had filed. And she told me that those were preserved for me, and that if I took the no contest plea offer, then I will be able to preserve those rights.
So, at the time that you pled, are you saying that you thought you had the
appeal rights? Yes.
And you went over a plea petition with Ms. Ryder, is that right?
Yes.
At the time that you were going over that plea petition, was that when she was making those representations to you?
Yes.
Okay.
It was actually on the initial date that I took the plea that she brung out the plea petition. She never ever talked to me about it in emails.
So I think you touched a little bit on why it is that you pled no contest to these charges. Do you think that you had a right at that time to go to trial?
Yeah, absolutely, I did.
You did?
Yeah.
Why did you enter no contest pleas then?
Because I was told if I entered the no contest plea, I would be able to sue Kerry Weiland for taking away my initial preliminary hearing rights.
And what about contact with your wife and children?
She said that I would immediately have contact with my wife and my children, and that I wouldn't be labeled a sex offender. And that was initially what led me into appealing the case, because they stuck me with the sex offender when they told me that they would drop the promoting prostitution to get me to plead to the delivery of an oxycodone, and I would be back at home with my wife and children.
You feel as though Miss Ryder coerced you into pleading?
Absolutely. She gave me until 5 o'clock to accept the state's offer, when previously, earlier in that day, I had been explaining to her that I didn't want to take the deal. I was already ready to go to trial, but she would never allow me to put on any type of evidence.
Okay. Just a few more questions, Mr. Johnson. If you understood that you did not have a right to appeal, would you have pled guilty or no contest?
No.
If you understood the possible defense and uniform criminal jury instructions that you had at your disposal in relation to your wife's potential testimony, would you have pled no contest to these charges?
No.
If Gail Ryder did not coerce you, as you said, into pleading, would you have pled no contest to these charges?
No.
Okay. Thank you. Nothing further, Your Honor.
All right. Cross-examination.
Mr. Mayfield,
Yes.
you've had, as you testified, a number of attorneys in this case. Is that correct?
Yes, sir.
All right. And you actually communicated with most of those attorneys in lengthy emails. Is that correct?
Yes.
And so it's not unusual for you to communicate with your attorneys in emails. Is that correct?
That's what they put on me. And I was always making an effort to try to meet in person with them. I actually met with David Kuhn, on 3 or 4 occasions, twice actually. And I've met with Jessica Kempthey once, and I've met with Kerry Weiland twice.
With that, you did communicate emails, and the email address you used were the emails that Gail Ryder was using. Is that correct?
Say that again?
Email address you used are the email address that Gail Ryder sent you those email addresses to, correct?
Yes, yes.
All right, I have no further questions for you.
Wow, poor. Them was poor.
Any redirect?
Just
Mr. Patterson?
very briefly, Your Honor.
Sure.
Mr. Johnson, you said that you had an opportunity to meet with Mr. Coons face-to-face.
Yes.
Did you feel that was a more effective way to communicate than emails?
Absolutely.
Nothing further, Your Honor.
All right. All right, Mr. Johnson, you may step down now and go back to the counsel table. And as I understand it, the petitioner does not have further witnesses. Is that correct?
With that and the exhibits and contents of the trial memorandum, petitioner is resting and moving to argument.
Okay. All right, and I'd already heard the defendant does not intend to call witnesses.
That's
so,
a
Mr.
lot.
Johnson, at this point, we have all of those exhibits as documents in the record and your testimony, which you just gave. Now the lawyers are going to make their closing arguments. Those arguments aren't evidence, but that helps the court understand all of these documents. And with that, Mr. Patterson, you may begin. And I would say that petitioner also has a right of a brief rebuttal argument as well. So, Mr. Patterson.
All right, thank you, Your Honor. For the most part, we'll be relying upon the arguments in our trial memorandum, but as I always do in these cases, I'd like to go over a few of the salient points here in case you have any questions for me. Essentially, what petitioner has done is raise 5 claims. Claims 1 and 2 and 3 or 4 are really just bifurcated claims that have been parceled out for purposes of preserving the right to appeal. And then we finally have one additional claim, and I'll go through each of those basically as if they were 3 claims. Claims 1 and 2 discuss that trial counsel was ineffective for failing to properly admonish Mr. Johnson about possible defenses that were available to him, jury instructions in support of those offenses, and the testimony that his wife, Jessica Johnson, the alleged victim in this case, would be willing to present before a jury. Trial counsel knew that petitioner's wife intended to make favorable statements at trial. That can be seen through her file in the declaration. That position, as far as Ms. Jessica Johnson is concerned, still hasn't changed. Can be seen in petitioner's Exhibit 11 that she is still willing to present favorable testimony and would have if she was subpoenaed for trial. Trial counsel throughout the representation, likely in an attempt to shield herself from wasted time, decided to use email as a primary form of communication. I believe from her declaration she has formed the opinion that Mr. Johnson was a difficult client and decided that it was better for her best interest to communicate through email throughout her representation. And quite frankly, that decision is extremely inappropriate. She asked petitioner not to contact her at times so that she may prepare for trial. Also inappropriate to turn your client away when that client has questions about their rights that you're trying to represent moving forward. It's very concerning behavior, and especially when we're dealing with complex legal principles at play, and in relation to Petitioner's Exhibit 13, the evaluation of Dr. Sweet, which the trial counsel was familiar with and understood the concepts within that report. That is kind of summarized in pages 14 through 15 of Petitioner's trial memo of kind of the assertions that are made in that report and the concerns that a trial counsel should have had upon reading that document. This has been given communicating via email is given less attention than you would to average client. And based on Dr. Sweet's report, it should be the exact opposite. This is an individual that should have been given more attention than the average client. Petitioner did not understand how his wife's testimony could be used to defend him against the charges against him. He didn't understand the legal principles that were at play, the jury instructions that we presented to the jury, the mens rea requirements of the crimes, how that testimony would fit in light of his defense at trial in front of the jury. It's clearly an ineffective assistance of counsel to ignore a client with these sort of deficits and cast into a pool of email contact only, which was not sufficient for Mr. Johnson to understand the legal principles at play. Those principles are outlined in pages 15 through 16 of Petitioner's trial memo. The prejudice from this is clear as day. Mr. Johnson took the stand and he told you, Your Honor, that he would not have pled no contest if he understood the existence of the potential testimony from his wife, Jessica Johnson, if he understood the legal principles at play, if he understood how those legal principles could be used to defend himself, if he understood the jury instructions and what the jury would be asked to do in light of that testimony. Also, without a firm understanding of those legal principles and the available testimony to him, he could not have made a knowing, voluntary, and intelligent decision to waive his constitutional rights, both state and federal, in order to resolve his case with no contest pleas. Claims 3 and 4 discuss the fact that Mr. Johnson was not properly advised of his right to appeal. I think it's clear looking at the trial court record from the transcripts, as well as Mr. Johnson's testimony here today, which coincide with that understanding of the transcripts. Not only did Mr. Johnson think that he had a right to appeal, trial counsel stated on the record that she told him that. And Judge Tripp was disagreeing with her, and trial counsel fought with Judge Tripp and said, I disagree with you and your reading of the plea petition and your understanding of the laws. What Ms. Ryder, trial counsel, was advising petitioner was erroneous. Essentially, he had waived all his rights to appeal, and he did not understand that at the time that he was entering no contest pleas. As a matter of fact, in the transcripts, I believe what he's saying is, I'm just doing this so I can go home to see my wife and kids, and I intend to continue to fight this, showing that his understanding was that he could, in fact, appeal that based on the motions that Mr. Coons have filed and other aspects of his case. And he was not making a knowing, voluntary, and intelligent to plea no contest on that basis. It was clearly an effective assistance to counsel to advise Mr. Johnson that, likely to just get him to go ahead and fold no contest so she could get rid of his case. And on those basis, petitioner is entitled to a reversal and remanding of his convictions and sentences back here to the Marion County Circuit Court for further proceedings. Finally, Mr. Johnson told you on the stand that he felt as though Ms. Ryder coerced him into pleading no contest, which I think also looked in the context of petitioner's third and fourth claim for relief, I believe is pretty apparent on the record. He would not have pled no contest if it wasn't for that behavior of trial counsel. And so for that reason, he's entitled to post-conviction relief on his fifth claim as well.
Let me ask you, from looking at the transcript, do you agree that Judge Tripp told the petitioner that he really, in practical terms, doesn't have a right of appeal?
I think if you look at that the colloquy as a whole, Your Honor, is that yes, there was something along those lines mentioned. However, if you place it into context with Dr. Sweet's report, the representation that trial counsel is making on the record along with Judge Tripp, at some point that conversation just kind of fizzles out. I don't believe that it was entirely clear, especially true given the light of Dr. Sweet's report to an individual with some of the problems Mr. Johnson has.
Mr. Johnson testified today, and he had earlier made statements. Let me see. How should I phrase that?
Lying, covering.
How would you agree that the Dr. Sweet's report was done on the issue of aid and assist?
I believe that's why it was done. Yes.
Yeah. Now, what about that report? How would you use it differently than establish that Mr. Johnson was able to aid and assist?
Well, Your Honor,
when you're saying trial counsel made error here, when she had Dr. Sweet's report, and yet her legal opinion was this no contest plea at this deadline. If we miss this deadline, this plea is gone. And that's, I guess, practically speaking, is coercion. And yet I don't think it's legal coercion. It's just, hey, you got a deadline.
That don't even make sense.
But how else? Why is it error to receive this report and acknowledge that your client can aid and assist? How else would you use it? I guess that's my question.
Well, and Your Honor, I guess for clarification, are you talking about in general, or are you talking about in relation to specific claims? Because I think
yes. In this case,
yes.
I'm saying if I had this report, and so he's able to aid and assist, but you're saying, well, but there's all this other information here. So how should she have used it if you're saying she made an error by misusing it? I get, and so maybe that isn't what you're claiming. Maybe that's just a bad question.
I wouldn't say it's a bad question, Your Honor, but it's not what I'm claiming. What I'm saying is that, and I think you mentioned my first point, which is if a report is simply to communicate he's able to aid and assist, that report would be about 5 words long. That's not what happens in aid and assist reports. It gives an in-depth psychological diagnosis. It talks about possibility of an individual not being able to process information at the same rate as another individual, that some forms of communication may be better than others. And upon reading the entire report, not just the last sentence that says he can aid and assist, knowing those psychological issues are at play, trial counsel had a duty then to follow through and properly explain things in light of knowing that knowledge. A simple email communication with complex legal principles and not meeting face-to-face, that's the inappropriateness when you understand that this is an individual that needs special attention to communicate some of these issues.
Okay.
That's how it fits
and
in.
that's help. Yeah, that is helpful to me. I guess, and I'll just ask this one. I was wondering if maybe you thought this was a sufficient report, that she should have done mental disease defense or something like that, but it doesn't sound like that's what you're saying.
No, that's not what I'm saying, Your Honor. I'm just saying.
Okay.
Yeah.
No, I understand that, and saying she should have done more to explain this. Okay. All right. Did my questions generate anything else you wanted to say at this point, Mr. Patterson?
No, thank you, Your Honor. I have a rebuttal argument if I want to address those.
Okay. All right. Thank you. Closing argument for defendant.
Thank you, Your Honor. In this case, our trial memo basically lays things out. Strickland standards are fairly specific when it comes to dealing with a trial counsel's kind of strategic decisions, and there's great deference given to trial counsel. But the evidence that is presented both in the exhibits today and the defendant's testimony clearly contradicts their claims. I'd like to start with Petitioner's Exhibit 13, page 10. That's Dr. Sweet's report. It's second paragraph down. It says, Mr. Johnson has an understanding of how to work and cooperate with counsel, but he does present a dilemma because he has had significant conflicts with previous attorneys. His claim is that people do not listen to him and do not look at his information.
Right.
He knows how to work with an attorney, but chooses not to.
Sure do.
Further, the last sentence in the next paragraph down, he said he gives up every right after a plea, including not having a trial and not confronting witnesses to have a plea bargain. When you then go back and look through the rest of his petition or his exhibits, specifically Exhibit 8, this is the affidavit of David Coons. They had 2 office exhibits, but then they exchanged numerous lengthy emails. He's communicating in emails with his attorneys while he's saying that he would rather have done it in person. Apparently, every single attorney he has that communicates in email, partly because he's the one sending them numerous lengthy emails. Further, this is somebody who is clearly demonstrating a difficulty interacting with attorneys of his own volition based on Dr. Sweet's report. When you read Gail Ryder's emails, you'll see it directly contradicts some of the things he said on the stand, such as she didn't want to meet with him. One of her emails says that she canceled their meeting because he was uncomfortable meeting privately. Further from that, you have emails where she specifically explains concepts that could be no clearer but are very easily explained in writing, such as the fact that he has no access to a preliminary hearing when he's been indicted. And yet even here today, he's talking about bringing suit about preliminary hearing. And as any attorney would know, it's easier to protect oneself when you are communicating and writing, and you're dealing with that in writing, just like the appellate issue where she has, in her emails, in the plea petition, in the court record, told him there's a very limited right to appeal. You have to appeal on colorable issues. Nowhere in there does she say you were going to get and win an appeal on the lack of preliminary hearing or any of the other issues he raised. Instead, she told him you have a very limited ability to appeal. And that's what was signed in the plea petition. As for the remainder of what's been alleged here, this is a defense counsel who very clearly went through all of the evidence. If you look at the police reports provided, they're lined out. She's looked at the evidence that's presented there. She has considered what is available, and she's provided an assessment to the defendant of his chances at trial, which were bleak, to say the least. This is a defendant who testified today that he wanted to go home and see his kids, and quite frankly, the only way to do that was to plead to a
Why when I
deal
wasn't
that
even
allowed
guilty?
probation. And one of the other things I'd like to mention very briefly is, so Defendant's Exhibit 101, kind of sub-Exhibit 11, which is how I received this from Gail Ryder. The second paragraph in that email, Ms. Ryder replies, "I did get the affidavit from your wife. Oregon law does not allow an attorney to use an affidavit in trial. It's no use to me. In fact, because it contradicts some of your wife's earlier statements to the police, it could actually hurt your case if I try to use it because it looks like she's now making up a new story to help you." In the context that this reply is sent, it's clear that she's responding to an email. So his claim that he didn't know about the affidavit is clearly incorrect because her response is, it's not helpful, and it's not helpful specifically because it looks like she's making stuff up. And that is an accurate assessment of that response, given that when you look at the police reports where she says, yep, he's here to help me out, he stays in the closet to protect me when things get rough, gives him most of the money, and then she later says, well, he had no idea what was going on, even though he actively was caught in the closet when the officers arrived. You have a very clearly fabricated story. So what you don't have is ineffective assistance of counsel on Ms. Ryder's part when she's assessing the evidence. You don't have an inability to communicate that to the defendant because she's told him about it. You don't have ineffective assistance of counsel when it comes to the appeal because she has told him repeatedly in her emails that some of his appellate claims are not allowable. She has told him on the record that it has to be a colorable claim. She has had him sign a plea petition that says it is a very limited right to appeal. They talk about it on the record briefly. And in the end, what you're left with is this idea that the defendant's claim that he was somehow unaware of what was going on is just contradicted by the evidence, which brings me to the final assertion that his desires were completely overborne by the defense counsel in this particular case because of the deadline. Defense counsel's declaration makes it clear she didn't set the deadline. The state set a deadline on a trial that was ready to go. If you read the rest of her emails, she says in one of them, your choice is whether to go to trial or not. You have this choice, but here's the evidence we're facing. This is what you're looking at if you get a sentence. This is the deal that you have, and you need to decide by this date. All of those are statements of fact. They are not coercion or any kind of undue pressure that would prevent this defendant from making his own choice, as recognized by Dr. Sweet's report, where he has the ability to aid and assist. He has the ability to sit and understand things, and emails are a perfect way to communicate with him because he has it in writing. He can read it as many times as he needs. In short, Your Honor, there is no evidence here that there is any ineffective assistance of counsel or that ineffective assistance of counsel would lead in any way to a different outcome in this proceeding. Thank you.
All right. Any rebuttal argument?
Just shortly, Your Honor. First, in relation to opposing counsel's representation of Petitioner's Exhibit 13 on page 10, that's about 3 sentences of a 10-page report that's focused in. It's ignoring all of the other information that's contained with that report that I was speaking about, both in my trial memo and orally here today. And I will just note that when Mr. Callery was going through and saying this was communicated, this was communicated, this was communicated, that was all followed by email, by email, by email. And I think that in the context of Petitioner's Exhibit 13, knowing that those problems do exist, whether or not he could communicate with an attorney in person, as Dr. Sweet's referencing, completely irrelevant to communication by email. I'd also like to point out that by saying that trial counsel went through all of the evidence very carefully and was making an assessment that was providing effective assistance of counsel. Unfortunately, what opposing counsel is missing is that when you're looking at post-conviction claims in the context where pleas have been entered, it's not about what trial counsel was doing behind the scenes. It's about what petitioner knew and understood at the time that he entered his pleas. So I don't care if she provided the best assistance anyone's ever seen reviewing police reports and stuff. If that was not communicated to Mr. Johnson, he wasn't able to make a knowing, voluntary, and intelligent decision to enter no contest pleas, and that was not providing effective assistance to counsel, certainly in relation to Dr. Sweet's report, which is Petitioner's Exhibit 13. So quite frankly, I think that defense counsel's argument falls flat on its face. We'd ask that you grant post-conviction relief at this time.
All right. Well, Mr. Johnson, post-conviction petitions, as we have done here today, try to establish whether or not a trial counsel gave you reasonable representation and used reasonable professional skill and judgment. And if they did not, did those actions prejudice you in your case? So I look at, in effect, the three different claims. And I look at Defendants 101. And certainly Ms. Ryder's position on this is much different than petitioner's opinion on this. But I do know that
she got to listen to me. Fuck all that.
As this information has come forward and Mr. Johnson testified today, he again repeated that he has an email that says this. He wanted to plead no contest, and sue the first attorney.
Where my lawsuit at then?
And that's come up again.
Sure did.
And I don't know, maybe post-conviction is considered suing your attorneys. I don't know about that, but I do believe from reviewing the record that Judge Tripp did clearly say that if you do a no contest plea today, you give up your rights to appeal. And she made it very clear to him. And he wanted, it's very clear today, he agrees, I wanted the benefits of the deal that I would get a downward departure out of prison and be placed on probation and be able to see my wife and children. Okay? So none of that is inappropriate or illegal coercion.
Yes, it is.
And it seems, as I view this, that Ms. Ryder, in an overall situation, it's always, is it reasonable under the circumstances? And as I look at all these circumstances, I do find that Ms. Ryder's declaration is persuasive to the court. And petitioner's
but your declaration,
I believe, is refuted by the record and certainly by Ms. Ryder's declaration. So, as I look at this, I see that Ms. Ryder, I do believe, based on the evidence, did perform reasonably. I do not believe that, looking at this evidence, that petitioner has met his burden of proof about the elements of the crime and the statements of his wife. In petitioner's memo, there's a statement, although Ms. Johnson's testimony may face some scrutiny in the form of prior inconsistent statements.
Then how did they do this?
That little clause, I think, is very important because given the circumstances of this case, the evidence that was admissible, the fact that Judge Tripp had already had pretrial rulings considering these issues from different attorneys, I find her actions to be reasonable. Now, I certainly do not find error, and I do not find prejudicial error. The appeal, claims 3 and 4, I think it is clear that Judge Tripp and trial counsel did explain if you take this deal and plead no contest, you lose your appeal rights. And as I've said on claim 3, coercion, certainly there's pressure on every defendant in a criminal case, but that isn't coercion. And I see nothing about coercion under these facts. It's just facts that were there that she communicated to Mr. Johnson, and that was available. So I will deny the petition for post-conviction relief. Mr. Johnson, I need to make sure that you understand, this is my opinion, based upon reading this, but you have the right to appeal my decision to the Court of Appeals. The important thing for you to know is you have to give notice 30 days from today. And I know that Mr. Patterson would assist you in coordinating with the appellate lawyers if that is what you wish to do, to appeal my ruling. Mr. Patterson, would you be able to do that?
Your Honor, I'll be filing an appeal.
They know I'm
as
gonna
soon as the
lose it, so
judgment
they're
is in the
telling
record.
me to appeal it.
All right.
It's just
Thank you very much. Is there
setup.
anything further from petitioner at this point?
No, Your Honor.
Mr. Pat? Okay. Anything else from defendant?
No, thank you, Your Honor.
All right.
he
Thank
will-
you all very much. We'll be adjourned.
We're off the record.
This was all the setup. That same judge is the one that put the stipulated protective order on me. Thank you guys for watching. Have a blessed